Hello, everyone, and welcome to the second session of the day, that is on IP due diligence. And the instructor for the session is Dr. Shivani Srivatsava. Hello, Dr. Shivani. Welcome to the session.
Hi, good morning.
Good morning. I think we have just a few other participants who are to join, but I guess we can get started, and as and when they join us. So happy to introduce Dr. Shivani here in the on the group here today. A brief introduction: Dr. Shivani Srivatsava is an associate partner at LexOrbis. She is a registered patent agent with over 16 years of experience. She holds a PhD in mathematics, MSc in plant science, and a law degree. She has also done an executive program from IIM Calcutta, and her technical areas of expertise include plant science, chemistry, biotechnology, biochemistry, and medicinal products. She regularly advises clients on filing and prosecuting patent applications in India and in the jurisdictions like the USPTO, EPO, etc. She works closely with clients and manages their IP portfolios. She has expertise in mentoring individuals, startups, SMEs, and also advising them on building an IP strategy and portfolio management. She is involved in various IP-related business deals, including IP valuation, due diligence. That's something that we are going to learn from Dr. Shivani today. Technology transfer, licensing, etc. She regularly attends conferences and seminars organized national and international events, and she has several articles to her credits. Welcome, Dr. Shivani, and we look forward to learn from you.
Thank you. Thank you for the introduction. I think so. This is the second session that I am taking.
Yes.
So like the students are same or is it a different set of people?
The students are the same. They have attended the first part of the session as well.
Okay. So then, okay, it would be good. I can't share the
You
screen.
mean the February sessions? Sorry,
Yes.
I'm sorry. Did you also mean February, the December sessions?
Yes.
There are a few new additions. Yeah, there are a few new additions, Dr. Shivani, to this group here. And we have a few law students like Nagaraju, Priya, and we have another student also who will be joining us soon, Harshit. So they are law students. So it's a combination of law students, entrepreneurs, and also professionals, IP professionals.
Hi, everyone. Good morning. So I understand. So this program is going on, and this particular module is with reference to the IP management, so which is intellectual property management, and I would be covering specific part of it, which is IP due diligence, and which is very required in when we are talking about business transactions and all. So let's just start with it. Also, when we say IP management, it is so you all know about intellectual property. Okay, so anything which is creation of human mind is covered under intellectual property, right? And it's a kind of an asset for a company. And when we say IP management, it helps to maximize the value and innovation of the company. It enhances the competitive advantage, revenue streams, and market position. I'll try explaining this in detail in next few slides. And protecting the IP and whatever time and money we spend in protecting it, it also helps in creating more IP, and it is very important for companies who are basically into innovation. And when we say IP management, the process we covered is identification. So first, we will have to identify the kind of IP maybe an individual or the company have, and we have to prepare a list of the documents and the type of IP along with the status and all. And after that, we will have, so this is just identification. So once we know like what different kind of IPs we have in the company, whether it's a patent, trademark, copyright, designs, And then we will have to see how to protect it. There are different ways to protect different types of intellectual property. And this is very important when we talk about enforcing our IP rights because it gives the legal protection to the owner. And it may be in the form of patents, trademarks, copyrights, and all. So once it is protected, then we can say, okay, so the IP belongs to me. I have a legal protection on that. I have a monopoly on that. And if someone, or maybe how to commercialize it, because when we talk about IP and all, it is an asset for the company. We can commercialize it. We can sell these properties to anyone else for monetization, or it can be given as a licensing, or there could be collaboration with other companies based on IP. And it's only not about protection because once we have the protection or monopoly, it doesn't matter or it will not help unless we enforce it. Okay. So when you have IP protected, and the moment you get to know about other people who are copying it or who are trying to copy it, it's always advisable to take an action immediately. Because if you don't take an action, there is no point having a protection on anything. So a very simple example, if I say about the normal asset, suppose we have a house and it's registered in our name, but if we do not put a lock on the house, anyone can enter. Okay, so this example is not like it's very simple, which I give to like all the individuals and startups because it's difficult for them to understand if we talk everything in legal language. So that's why when we have protection, we will have to enforce it, and for that we will have to monitor, and we will have to let people that my IP is protected. So whenever you talk about the invention, wherever you are mentioning about the invention, always say that the invention or the patent is pending or protected. It's a brand name. Registered brand name should always use R symbol for all the copyright related material. Always use copyright symbol. You have the registration certificate for IP, but it will not be available to everyone. People may just maybe honestly copy it. They may not having any idea whether it is protected or not. And there is something which can always be used by the other people who are trying to infringe it, that they can say we were honest infringers. Hey, we did not know that IP was protected. So this is our first duty. Once we have protected, we should symbolize it. Okay. And anyhow, wherever we are mentioning, we should always mention that this is protected and the rights belong to the company or person. So when IP management, the important part is IP audit. So so most of the people know when the company audit or accounts audit is happening. So this is exactly similar how we do accounts audit. So in IP audit, we discuss and talk only about intellectual property of the company because it helps when we do IP audit, we would be having an idea about all the IPs of the company. And it's a systematic review of a company's IP asset to manage risk and inform strategic decision. Because once we have all details about the IP of the company, and if we are going to take any decision based on that, it would be helpful. Because if we don't have anything documented, we won't be able to decide like what to do or what all can be done with it. So the purpose of IP audit is to ensure that we have a proper protection on IP. We should also assess the value of the IP because it also helps a lot in valuation of the company. This is intangible right, but when we talk about the value of the company, even in the accounts book, we can put a number against IP. And it also helps with how to utilize IPS because this is like normal property. We can sell, we can give license, even we can give IP to other people. So for IP audit, if we talk about the steps, the first step is planning. So planning, like for everything, we will have to have some plan. So when we talk about IP audit, we should initially define the scope. Okay, why are we doing it? What will be the objectives? What kind of methods we would be using it? All these are important because accordingly, we would also get to know the kind of expertise we would be requiring for this, or the kind of budget allocation is required, because there will be a cost and time involved in all that. So, and then we will have to, that's why I said the objective and scope is very important. And we will also have to put the timelines on different milestones. So, like, it's like we identify the IP, then we file the applications, what will happen after protection, how should we utilize all that information, all that. So, this will be covered in the first part when we are talking about the planning of it. The second step is data collection. There we will have to identify all the data of the company and every information related to IPSS. Okay, so IP audit means it's not mandatory that company would be having already all the IPs registered. So suppose when we do an IP audit for a startup who doesn't have any other idea about IP, so because they don't know where the kind of all IP they have. So when we start working on data collection, we will make a list of all the IPs that belongs to the company. If it's a tech company, there may be multiple of inventions, even related to one technology as well. So we will have to identify all that. If there are maybe if they are into products, there will be products which they are selling in the market. There will be trademark associated with it, even if the services that would be there. If the startup is pharma company or biotechnology, they might be having multiple brand names for each product. So all that, so all this will be covered in data. And if it's a software company, then also we will have to see the kind of terms and policies they use with reference to software, or if there is open source licensing or not. And for biotech and pharma companies, there are a lot of regulatory requirements are also there. So we will have to see, okay, if all that are fulfilled or not. So once we have all the data collected with us, then we will have to analyze it. What is the kind of information we have gathered? So then we will have to see the legality, validity, enforceability, and value. So if the patent and all was already filed, a trademark is already registered, we will have to see about the legality of it, whether it's a registered or it's still pending application, who are the owners, if there were any legal proceedings happening with reference to all these things. So this will be the part of analysis. And after the analysis, a report will be prepared. So report would be maybe graphical representation or a summary of everything altogether. So that's how we do IP audit. And so there are certain key considerations which are being considered during IP audit. So basically legal compliance or risk management, strategic alignment. So when we say about legal compliance, we will have to see if we are following all the legal requirements, whether it's IP related or any other legal requirement or any regulatory requirement which may be there for any food industry or pharma industry or biotech. So accordingly, we will have to see if the company is complying with all these requirements or not. And then we will have to see about the associated risk. So when we identify, we will have to assess if there is any infringement happening or not. So when we say infringement, we will have to see if anyone else is infringing our IP. At the same time, we will also have to see if we are infringing someone else's. So we will have to see it from both point of view. And next is strategic alignment. So for that, we will have to have one IP strategy for the company. there should be a written document on that so that we should follow that. And it's very important. It will keep things very easy if you have these kind of strategies, or if you have any IP guidelines already in place in the company. So when we come to IP due diligence, it's a kind of an IP audit. So IP audit can be done at any time. But when we talk about IP due diligence, it will be done when it is required. So so we will have to understand when exactly is it required. So before any transaction, when we are talking about merger and acquisition, or if we are trying to license or sell the patent, so that time an investigation needs to be done to assess the value and risk of IP asset. That is IP due diligence. So the due diligence we do in everything, but when the due diligence is related to IP, we call it as IP due diligence. And context, I mentioned that it will be required in any transaction process. So these are the different kind of things where IP due diligence is required, or it should be done, should be mandatory. So merger and acquisition or joint venture. When the company or a startup or anyone who owns the IP, they are being acquired by any other company, or if they are looking for joint venture, that time we will have to see the IP belongs to the company, and it should be done for both the parties. So even if we are giving license to the other company, we will have to see uh, if the other company is capable enough to handle the IP or not. Because when we are talking about the sale of IP, you just sell it, you get the money, and it's done. But when you are giving the license to other company, IP still belongs to you. So you should always see the kind of license you are giving to other parties. So if it's an exclusive license which says only the X company would be able to use your IP, even you cannot also use it. So suppose you are giving the license, you would be getting some monetary benefit out of it, but the company is not utilizing your IP. Then there is no point, because you also cannot do anything. You have already given the license. Maybe there will be other terms and conditions, the license agreement, that if it is not being fulfilled, you can always terminate it. But that action will be taken once everything is being done. So all these should be done before we sign any legal document. So financial transaction, and I say like buying or selling of business division or IP transfer. So suppose sometimes the companies might be having different business divisions based on different kind of technologies they have, and they may give or maybe sell the IP for only one division. It's not mandatory that company is giving the complete IP to the other company. And it is also required before launching a new product or service. Because so we usually say that the term being used is FTO, freedom to operate analysis. So when we are going to launch any product in the market, it is always advisable to do FTO to see whether you are free to operate in the market or not, whether the product is uh, freely useful without infringing anyone else's IP or not. Because sometimes you might be having an IP on one process that could be maybe chemical or pharma related, and it is being useful to manufacture one product which is maybe someone else's IP. So even if you have a specific process, maybe that is cost effective or maybe requiring lesser raw material, it's saving time and all, but you won't be able to use it in the market because the process you are using to manufacture an X product, that product is already patented by someone else. How will you sell it? What will you do with the process? Nothing. In that case, you can get in touch with the other company. You can have cross licenses. And so, because if you have a very good process, it will be helpful for the other company as well who are also manufacturing the product. So, once you have a license agreement placed between both the companies, you will be able to use freely use their product, and the other company would be able to use your process. So it's helping both people. And FTO, why do I say that freedom to operate analysis is required? Because when any product is being launched in the market, a lot of time, energy, and money is involved. You There is a lot of R&D is involved before launching the product, and even a marketing strategy and everything. All the plannings will be there. If FTO is not being done and the product is there in the market, after that, when you get the notice from the IP owner, you will have to immediately stop selling the product. And that could be very difficult at that moment. So that's why we said the precautions are always advisable. Because once the damage is done, you can look for the other things. But if we are already taking precautionary measures, we can avoid all those issues in the future. So IP licensing, I have explained. So when you are giving license to the other company, there may be a different forms of licensing, exclusive, non-exclusive, or maybe territory-wise, maybe for specific requirement, or you are giving only for manufacturing, and then you're not giving license to sell the product, or if it is only distribution rights and all. For bankruptcy and layoff, even for layoff, which is commonly happening these days, we will have to see, because during the layoff, it happens to the employees. And mostly the employees are the inventors of the IP being created in the company. We should always have the document in place in the company which talks about the ownership of IP. Because that happens, I have faced these kind of issues that people, when in the employment agreement, there is no mention of IP. And when the person is leaving the company, that time also no document is being signed, and the person will go outside and file the patent application, or he will start using the IP in the other company. Sometimes they start their own startup. So all that can be avoided if we are vigilant. So always, we should always in place the IP agreement with all the employees, which properly says about the terms and conditions, like who will be the owner of IP, which is being created during the employment time of an employee. So again, why is IP due diligence required? Why should be conducted? So again, risk management to uncover IP litigation, because if we don't do this due diligence, and if we only have a list of IP, that time we say, okay, so this particular company has 10 patents in their name, and we are going to buy that company, we will check those 10 patents. But if there, those like out of 10, if there are even one patent which is stuck in legal battle, it would be very difficult, because the moment you buy the IP, the issues will start. So that we should able to check what is the legality associated with that particular intellectual property. If there is any disputes, or if there are any invalid patents, that could pose financial risk. Because once the deal is done, payments are done, then it would be difficult. You won't be able to do a lot after that. The second point about the valuation, because when we are talking about anything buying or selling, we will have to see that an appropriate amount is being put. And how will we get to know the amount? Because if there's a product being available in the market, there will be an MRP, or there will be a price associated with the product. But for intellectual property, there is no specific price. So we will have to do an IP valuation to understand the cost of IP. And there are various ways. I think there is a separate session on IP valuation.
Yes, yeah,
Yeah.
we have a separate
So,
session. We
uh,
will.
so that time it will be discussed in detail, but valuation is very important. And so usually the valuation is being done by CA and they do not uh, like specifically focus on IP. So even if we talk about IP valuation, mostly it is the company valuation. Okay, so it should not be there because when we have a technology involved or there is an IP, we should put some additional efforts to identify what will be the value of IP for the company, for the existing company, or if the IP is being sold, what will be the value the buyer would be getting in future. And so once we do due diligence, we can have strategic planning specifically related to IP. This will ensure the company have a specific IP policy or IP strategy, which helps in the long-term business goal. Earlier, it was not there. People were not focused a lot on IP, and then there is a second generation came for them. The IP was important, but that was only to publicize it. Okay, so they were not keen to have patent granted for the technology. The only interest they had was file a patent application, get a patent pending tag. That's all. So that time they were not focusing whether the technology is strong or not, and if the patent application is being filed, whether the claims are strong or not, because all these things matters after the grant of the patent. When we are talking about the valuation, the company might be having 50 patents, but if the claims are not strong, then what is the point of having 50 claims? Or if you're filing the patent application with specific or narrow claims, and if there is no one who is interested copying your technology, then what will you do with the protection? You can just simply use it. Nobody is interested in the technology. So even at the time of filing patent application, we will have to see that the patent document should be strong. So these are the kind of IP which are required or are very important. So patent, trademark, copyright, design, and trade secret. There are other forms of IP as well, but these particular are being considered very important for a company. So, and I'll just briefly cover them because I think you guys already have a detailed session on different forms of IP, or you would be, or you maybe law students who have recently joined, they have a course on IP. So when we say patent, patent is for technology or innovation. So what do we actually protect in patent? It's like I have a technology or a particular technology which is already there in the market or it's already there in public, and there were some problems associated with it. And I'm coming up with a technical solution of that problem. Okay. So when we say technical solution, that means the technology is involved. And because it's a unique solution which was not done by anyone else, obviously the protection is required because if there is a long-term problem associated and you come up with the solution, then obviously people would be interested in it and they may start copying it. So it's always good to have protection on it. And the basic criteria on patentability are novelty, inventive step, and industrial application. So one, the invention should be new. That means it should not be available in public in any form, including oral knowledge. The second, it should involve at least one inventive step. So when we say inventive step, that means the technology or the invention you are talking about, it should not be obvious for people's skill in the art. So there's a specific definition like who can be considered as person skill in the art. So they are the people who are having experience or they have expertise on that particular domain. So suppose if there is any invention related to pharma companies, so all the pharmacists and doctors and all, they can be considered as people skilled in the art. The third important criteria, the invention should be applicable or useful in any kind of industry. If even if the invention is there, which is new and inventive, but if you're not able to use it in any industry, you cannot get patent on. Apart from that, there are certain inventions. Those are not inventions. There are certain things which are not being considered as inventions. So when these are not invention, patent is not possible. So these are called as non-patentable inventions. So there's a list of inventions, like if there's any discovery, the discovery cannot be considered as patentable invention because that particular thing was always available. We have only discovered it. That is not, we haven't done it. So for minerals and all, we might get patent on the process, how we are extracting the mineral, but we cannot get protection on the mineral as such. Apart from that, the method of agriculture or surgical method of treatment, all these are covered under non-patentable inventions. So uh, when we are working on the technology and protection, we should also be aware of all those things. The second form of IP is trademarks, which is related to branding. Trade means business and mark any identification of the business. So if I have anything which I use to promote the product and services of my company, it can be trademark. It can be name of the product or name of the company. If we have any trade dress or specific color combination, tagline, anything which helps customers or consumers to relate the product or services to the company. Everything will go under trademark. Next form is copyright, any artistic work. Okay? So when we say any artistic work, the expression of an idea is being covered under copyright. We don't say the idea. We always say the expression of an idea. Okay? How we are expressing an idea, that is my copyright. So it's like for small kids or everyone, when I give this example, it's very easy for them to understand. Because when we were small and in the class, maybe UKG or grade 1 or grade 2, in the class, when we have this drawing class and we draw a scenery. Okay, so for all the kids, it will be similar concept. They would be having two mountains, one rising sun, one palm tree, one hut, there is a river, and then few birds. So this is an idea that will be there on every drawing sheet. But the way every kid is expressing it, every kid has their copyright on that particular drawing. So that this is how we explain the expression of an idea. Okay, the concept is same, but the way I'm expressing it, that is my copyright. The way you would be expressing it, that would be your copyright. The next, so apart from, so this could be for literary work, artistic, cinematographic, musical, and all. And so next is industrial design. There is a slight difference between industrial design and patent. Okay, in India, we use the term patent and industrial design, while in few other countries, it is being called as design patent or utility patent. So design patent is for industrial design and utility patent is for normal patent, what we use in India. In industrial design, we protect only the feel, look, or configuration of the design. We don't cover, the protection will not be given on the function of the product, like how this function. It will only cover the look and feel of the product. And for that also, there is very good example. When we get the mineral water bottle, so usually there were two bottles in the market. One was Bisleri and one was Kinley. So Kinley water bottle was having a different shape of the bottle. And there are people who buy that bottle only because of the shape. Both are 1 liter bottle, having the water, the requirement is same. There is nothing in the water, it's same. There is no taste or anything. but people will prefer buying one particular product because of its design. So that is being considered under design registration. And if I give you one more example, suppose there is a chair, specific design of the chair. So usually we have four legs in the chair, and there is a chair with three legs. So if we there is a three-leg chair, and when we talk about the look and feel of the good, it is industrial design. But the moment we talk about the functionality of three legs, like the way we would be putting the legs on the chair so that it will help in balancing, there comes a technology or the functional aspect of the product, then it will go under patent and not design. The next one, very important IP is trade secret. The only issue with trade secret is we cannot protect it. The laws are in India, there is no law to protect the trade secret. You will have to keep it secret. And it is also very difficult to take an action if there is a leak in trade secret. So suppose if you have a recipe and then if there's other restaurant who are trying to copy your recipe, and when you say that you were copying, they are copying your recipe, you will have to disclose your formula. The moment you disclose the formula, the trade secret is gone. So when you have something, keep it secret. All of the forms, the patent, trademark, copyright, and designs, all can be protected. There are ways to protect it. Copyright is inherent law, inherent protection. So you don't have a mandatory registration to protect the copyright. If you want, you can go for registration. So even if you don't have copyright registration separately, you can use copyright symbol because the copyright is is an IP that belongs to the creator the moment the work is being created. So for copyright, it's not mandatory. For patent, trademark, and design, you will have to file the application, get a grant certificate or registration certificate from the government to enforce your rights. So there are three important IP concepts. So one is global IP coverage because all the IPs are territorial in nature. Means when I protect my IP in India, it will be applicable only in India. So if I have patent in India, someone is trying to copy my invention in US, I won't be able to take any action unless it is separately protected in US. So we will have to identify if the global protection is required or not. That will be based on the business or the market of interest. Because if I have IP filed in 50 countries, I would be spending a lot of money. It's not easy. It's very costly to protect the IP in every required country. It will take time. Main laws are same, but every jurisdiction would be having some other national laws as well. So you have IP protected in 50 countries. You're spending money. Once the IP is protected, you will pay additional money to maintain it. And then if someone is copying it, again, you will spend money for the enforcement, for the litigation and all. At that time, you will have to see what are you getting out of it. Are you generating any revenue out of this IP or not? So you have a business facility only in India. You are selling the product in India. You are providing the services in India. Obviously, the revenue is being generated for the company based on IP. But if you have the same IP protected in US, so and if you're not generating any revenue, it's only expense for the company. Apart from that, you're using this, you're just flaunting that you have IP in 10 countries or 50 countries. There is no monetary benefit that company is getting. So we will have to, if there's a market in other countries, or if you're looking for investment, or if you're looking for joint venture or anything other countries, you should always go. But you should never file or never protect the application only for the sake of having it, because this is only an expense for you. And then next is IP infringement. And so we will, that these two I have already discussed. So we will have to see whether the IP is being infringed by others or if I'm infringing someone else's IP. So this is a very important point that we should always be aware of it. We should always do due diligence to understand all these things. Okay, we should keep all these records. Freedom to operate, this is to assess the risk of infringing other patents. So before launching the product, or even if you're working on any of the product, even before research, at the time of research, you can do freedom to operate analysis. If you already have the concept written in a document, you know that you will be doing the research on this particular product, and then the product will be launched in the market. You should see if this is infringing someone else's IP or not. So the IP due diligence, so we discussed the IP audit process. So the process is similar. There will be some differences, but the steps would be same. Okay, so again, the planning, data collection, analysis, risk identification, reporting. So for again, at the time of planning, the scope and objective both are very important. IP due diligence will be done by someone else. That will not be done by the owner of the company or any employee of the company. Okay, it will be like third party service provider who will be doing IP due diligence for them. So when you're hiring someone, again, their time would be required. You will be paying them based on the time they are putting and efforts they are putting. So for that, the objective should be clear. We should be having all the milestones, like what will be the timelines for this process and all. And accordingly, we will have to decide, okay, so which form we should identify for IP due diligence, because the moment you have all the budgetary approvals or you know about the financials and budgets required for IP due diligence, then you will be able to understand, like you will be able to identify the firm required for it. If you have more budget allocation, you can go for a big firm. If you have small budget allocation, you can go for a small firm. So that's where the planning is important. And data collection, then we will gather all the data. We'll identify all the associated data for IP and we collect it. Next, after data collection, analysis is required. This is like today's data scientist job. If you see, it's very important. Like most of the companies, there are many startups coming on data. So data is important right now. And then once we gather the data, how we are analyzing it, it completely change the objective, what we do with the data. So even if you have all IP related data available with you, if you don't know how to analyze it or how to use that data, this data will not help you. You have everything documented, everything is available, but you don't know what to do with that. So that analysis is required, and after the analysis, we will have to identify the risk. If there is any IP battle or any legal battle is going on, or if there are future risks related to IP, so that information will be available once we are done with the analysis. And after analyzing and identification of these, we will prepare a report, and the report would be having all the information. It will be a comprehensive report covering everything. It will talk about the data, it will talk about the analysis, it will also talk about the associated risk or identified risk, existing risk, and what would be the associated future risk. The report will cover it. And that report will be submitted to the company by the agency who are doing due diligence for them. So the main key considerations which are there for IP due diligence, The first, very important, is ownership and control. We will have to see who owns the IP or who has right to use the IP. Because when I say ownership and control, one, there will be a person who has filed the application or the patentee or the trademark owner. They own the IP. But if an exclusive license is being given to X company, even if they own the IP, they are not able to use it. So that's why the important point that we should check who owns the IP and who has the rights to use it. And for that, all the documentation will all support documents or evidences would be required. Freedom to operate, okay. As we will have to assess whether the company's use of IP infringes on others' rights or not. You are going to buy a company, you are interested in in a tech company, and the product is very famous in the market. The deal is done, and after that, that time you realize, okay, the product was important, the technology was excellent, but you are not able to freely use the technology in the market because there is some overlapping on certain technical aspects which are covered by someone else. So all these things are we should be aware before. The, the next, the key consideration, like IP agreement. We should check all the agreements related to IP which are already signed or executed, which are there in the company. We should review all the agreements, okay? And if it is not being done, we should do it immediately. Terms and conditions are very important. So sometimes what happens, people will prepare an agreement, they will Google it, they will get a template and draft the agreement themselves, and they will execute it. Okay, so for the time being, that might be okay. But when you are talking about enforcing the terms and conditions of the agreement before the court, then you are realizing, okay, the terms and conditions are not strong. Okay, so that's why we have lawyers, we have experts. So you don't have to do that because when it comes to legal requirements, it's always advisable to go to an expert instead of doing yours. Because see, even for medical, we say when someone is having medical issues, when we are having a fever, you might be having one paracetamol. But if the issue is more than that, we always go for the doctor. When we were small, we used to go to a physician for everything, whatever is the problem. But now there are experts available. We always go to the experts for any medical related issues. So same is there for IT or any legal issue. We should always go to an expert. Okay? Because see, I'm asking if you have something related to IP and if you are going to an advocate who specifically handles criminal law. So he knows about law, okay, all legal implications. He would be having an idea, but he may not be considered as an IP expert. So that's why instead of doing yourself, saving money, it's always spend some money, go to the expert and get things done properly. And international protection ensure all IP extends to all critical markets. This I covered in earlier slides. So we should identify the business or the prospective market or the investors and all. Based on that, we should look for international protection of IP. We just don't do it just like that. We should spend time, have some information. There should be strategic decision on that, whether the international protection is required or not. Because if the technology is good, and if you think you may get a potential investor from maybe 5 other countries, in that case, you should do that. Because once you get the even going to an investor, you will have to show something. You will have to show some potential. You cannot go to a US investor saying, I have patent in India. He will not be interested. He will be like, I have a company in US. I'm not interested whether the IP is granted in India or not. Because I have a presence in US, I would be more interested in US patents than Indian patent or any other jurisdiction. So we should have some strategic decision whether the international protection is required or not. There are common pitfalls which are being happening currently. I see this happening very frequently. So one, incomplete search. Incomplete search, when we are talking about filing patent application, if my search is not done or if my documentation is not done, I would be filing the patent application. I may not be covering the complete invention properly. Okay. And so for that, or if we do a patentability search before filing the patent application, and it is always advisable because when you do patentability search, you will get to know whether the patent is like you should go ahead with patent filing or not. Suppose you come to me and I'm giving you a negative search report that are saying that your invention is not patentable. In the search code, there will be reason. Okay. If I'm saying the invention is not novel or not inventive, why am I saying? I will be sharing the maybe 5 documents. So these 5 documents are already there in public domain. Your invention is doing exactly what these 5 people are doing. You can always go back to your research, modify the invention, do some advanced research, and come back with a patentable invention. If you don't do a patentable research report, you come up with the report with the idea or the innovation, you file a patent application. You may not get it granted, or if you're filing patent application with half information, that is not giving you strong patent. So that's why the incomplete search is not good. And it happens. Then underestimating non-registered IP. So people, they may not spend a lot of time on identifying or have a separate strategy for unregistered IP, which covers the trade secret and copyright. So if you have a trade secret, the one thing you should know about it. Okay, you should identify it. Obviously, for trade secret, you cannot go for protection. The government cannot give you the protection, but you will have to protect it. So first step, identify the trade secret. And the second, do all the measures to protect it. And for copyright as well, so people have a very good software or a very good content or a lot of things which are related to copyright, but they don't talk about protecting, or or maybe they are not aware. So even the website, if you see all those websites, it always have one line: the copyright belongs to the company, and then it's always mandatory. It's always advisable to put the year. Suppose you have created a website in 2017, or you have created any artistic creation in 2017. So whenever you put the copyright symbol, you should always mention the year. That means this particular work was created in 2017. And the third important pitfall is neglecting third party rights. Okay. So you ignore the impact of licenses, joint ownership, and encumbrance. Okay. So you have maybe if you are giving a license to a company which uh, for maybe manufacturing the product, and maybe that particular company might be having another license with a Y company. If, as per the agreement or license, it says the X company cannot function on this particular industry. And when you are giving license to company X for the similar thing, you're done with the license. Okay, license agreement is signed. But because of there is a clash with the other agreement, they won't be able to really uh, manufacture the product. So even to give the license, the due diligence is required. Whom you are giving the license, whether they would be able to utilize your invention fully or not. So we should check on all those things. And these things are being commonly ignored. So when we talk about the best practices for effective IP due diligence, that is it. Engage an expert. Always go for the expert. Don't even think about saving money here. It is very important. You're spending a lot of time, energy on the innovation, building the brand, but the moment it comes to the protection or enforcement of it, that time you're thinking about saving the money. If you're not going for good advice or correct advice, whatever you have spent in past, it's all waste. So that's why always go for the expert. And then you should have the second is comprehensive review. Uh, you should have all the documents in place, and that should be reviewed at certain time intervals because the time is changing. Your IP strategy might be changing. So if you have all the documents in place with you, all these documents are all always available for review, and whenever you want to change anything, you can do it. So that review is required. There should be a time interval, maybe 1 year, 2 years, 3 years. You should check all those agreements and all the documents, and you should rework on them. The third important point is continuous monitoring. Okay? So IP landscape or dynamic regular updates are necessary. So why monitoring is important? Suppose you are a tech startup or a tech company. You are working on certain kind of technology, but if you are in the software industry every 2 to 3 months the technology will change. So if you are working on a software and if you don't see what's happening outside, which direction the market is going, you would be working on something which is not useful for you or which is not useful for anyone when the product is there in the market. So that's why the continuous monitoring is required. It's always good to have an idea about IP landscape. You should always be aware where the technology is moving. So for that, we do this landscaping, patent landscape, which gives an idea about the movement of the technology, the way applications are being filed or the way the patents are being granted, who are the competitors, if we talk about the filing, how the graph is going, whether the number of filings are increasing, or if there is a saturation or there is a dip. So if there is a dip on that particular technology, there is no point working, spending more time and energy on that. For any research, always go for landscape before spending time on it. People go for landscape for market research. They don't do patent landscape before spending time on research. See, because when we patent documents are very important. If you start studying the patent document, you will get to know the future products because the companies who are filing patent application today, they might be launching the product in the market after 2 years. So if you start studying the patent document, you will always be aware of the future technology in the market, the products or the services which would be there. So that's why it's required. Once you have the landscape, you would also be having an idea about the areas which are very crowded. So in technology, if there is a particular group or any sub part of the technology, many people are working with, and there will be other niche technology. So if you're working in the area which is not being covered by many, there are high chances you may come up a better innovation or you can come up with the invention. You can go for the patent. But if there is a already crowded space, you may not have a very good future opportunities on that particular space. So that's why the continuous monitoring on the technology on IP is always required. You should always be aware of what your competitor is doing. So these are the checklists that I have prepared, which should be considered when we do due diligence. Okay, I'll just read out one by one. So for patents, we should know the list of the patent, list of granted patent and pending patent both. That's why I've used the term patent and patent application. Then assignment and ownership record. So because when we are talking about the proprietary ownership of the patent, there should be a document in place. There should always be an evidence which shows the ownership about the patent, who owns it. And the examination and prosecution history. What happened during the life cycle of the patent? What happened after we filed the patent application and before the grant? About the licensing and royalty agreements, patent infringement opinions, and litigation history. So patent infringement opinions, so there is something patent infringement analysis. So that can be done from both sides of, there could be two approaches. One, you are checking if you are infringing someone else's patent. The other one, if other people are infringing your patent. So this should be done between a time interval. You should know if people are infringing. If they are infringing, you should always go for a legal action against them. And you should, in the due diligence, you should be aware of any litigation history related to the invention or of patent. So when I say litigation history, the litigation history could be related to infringement. Otherwise, there could be a litigation related to the ownership of the patent. Patent application was filed, and then there is a dispute. Like someone would be saying, no, this patent, the technology was mine, and the other person has filed patent application. He's not the actual owner of it. I'm the actual owner of it. So all this litigation history, the person should be aware, and all these things should be checked during the due diligence. For the trademark, again, list of the trademark, registered and pending application, or registered or non-registered trademark, about the ownership of trademark, the use. So in the trademark, the use is very important. For patents, obviously, the novelty is required. So when you file patent application, it should not be available with public. But that doesn't happen with trademarks. There are chances when you file patent application, trademark application, that time you were already using the trademark. So you started using the trademark in 2010, but you're filing trademark application in 2024. You should file the trademark application claiming prior use from 2010. Because if you file the application as proposed to be used, it's not good. You already have a brand value in the market. The product were already there. You already have a customer base. All these things should be covered in trade. The licensing and coexistence agreement, trademark infringement opinion, and litigation history. So that would be similar. Again, the litigation could be related to the infringement or ownership of the trade. Then copyright, we always have a list of copyright works, even if it's registered or if it's not registered. You should know kind of copyrights you have. And again, regarding the ownership, for the copyright, for most of the things, the patents, the first right belongs to the inventor. For copyright, the first right belongs to the creator. So if the creator of the copyright or author of the copyright and owner of the copyright are two different people. Suppose owner is the company and the author is an employee of the company. So there should be a third document available which talks about the ownership of copyright. So if the author has created something as per the job, then, and if there is an IP clause in the employment agreement which says that any copyrighted work created by the author will belong to the company. So all those documents should be available. Again, the copyright assignment and transfer. If the copyright was being assigned or transferred to other parties, the agreements and all, the documents should be in place. Again, litigation history. For trade secret, so we should identify the trade secrets and confidential information. We should know how we are protecting it and what are the policies in place in the company to protect trade secret and what kind of procedures or protocols we follow. or if there is any license or transfer agreement associated with trade secret. And again, the associated litigation history. Apart from IP, there should be some checklist which should be there related to business information. Okay, the company and corporation and organization document. When was the company incorporated? What was there in memorandum of association? How many stakeholders are there? What are their rights? What the stakeholders, directors, and all, and their financial statements and tax records. This should also be checked. The customer and supplier agreements, if there is any vendor agreements or supplier agreements, employment agreement and non-compete clauses. These are part of the employment agreement. Any compliance or with as per the required laws and regulations, these should be in the checklist when we are doing IP. So when we are into IP, it's not only that we will be talking only about patent, trademark, copyright, or this. There should be general information that should also be covered. Then last is IP management. We should understand the kind of policies, protocols, procedures being followed in the company with respect to IP portfolio management. First, we will have to identify is it their IP portfolio for the company. So when we say portfolio, it's not one patent or one thing. When we say portfolio, there could be it's a bundle of IP. They might be having multiple patents, multiple trademark, copyright, and all. And then we will have to see the internal IP. If we have any agreement signed amongst the even the business owners, all these should be there. Or if there is a procedure, okay, how protocols being followed in the company, it should be a written document. It should be available. And this document should be checked when we do due diligence. Because once we document everything, then only we can check whether all these requirements or procedures being followed or not. If these were not being followed, we can identify the associated issues and we can rectify. Or if there's any change in the process required, that can be done. But all that can be done only if it is documented. If it's all verbal discussion, it's like there is a team call, we are having, okay, we just talk that we'll be working on 10 innovations and we'll try to pilot 15 patent applications. Nothing is documented. Then it will not help. Because when we are talking about due diligence and all the evidences would be required. We cannot go on what was said. We will have to see what was recorded or documented. Then compliance with record keeping requirements. If there are any regulatory compliance or anything, even related to IP, whether it is being documented or not. So we will have to check on all this. So this list would be very helpful. I have given one assignment also. So I did not provide a separate answer sheet for that because everything is pretty covered in the slide and the checklist is already there. So I covered one case study. It was very difficult to get a good case study, but this was. So this is related to Rolls-Royce trademark. So what happened? Volkswagen acquires Rolls-Royce manufacturing rights. Rolls-Royce and Bentley's manufacturing rights. The deal was around $900 million. What they missed here is they did not check who has the trademark. Okay, they got the right, everything on manufacturing the product, but there was no check on the trademark. And the trademark of it was owned by BMW. So even Volkswagen got the manufacturing right, they couldn't use the Rolls-Royce trademark. Then what is the point? Suppose that you are having the car is there in the market, but if the Rolls-Royce brand is not there on the car, the big car interested in that car, they do not buy it. You just put Rolls-Royce on the car and the cost will change. So you have manufacturing rights, you are manufacturing the same car, but you are not able to sell the car for the price it could have if he has the brand on it. So, so what was the lesson out of the critical importance of comprehensive IP due diligence? That is the due diligence which was required. So I think this case you will like you can easily get why it was important because we know about all these brands. And even so, if I give it simple, if we go buy clothes from Zara, Marks and Spencers, and all, and there are the small markets. For example, in Delhi, Sarojini Market is there. You get the similar clothes in there as well. But if you get a dress from Zara that might be maybe 3,000 rupees, and the same dress in Sarojini Market you will find for 300 rupees. But there is a person who is like who always get the Zara dress. Even if the same dress is being sold in any other small market for 300 rupees, the person will not spend 300 rupees because for them the brand is important. The same dress, when it goes in the Zara store, the brand value changes the pricing. Okay, so that's right. So even so, all these are important. So, in fact, the oversight affected the transaction's intended value and strategic outcome. So, if you see the $900 million they spent to get the rights, but just one miss, and it was considered as a blunder. It was not considered as a good deal. Because when they were signing the agreement and all, they must be thinking, okay, we are getting Rolls Royce and Bentley. But when the deal is done, the moment BMW is saying, no, you cannot use that because the trademark is with us. That time they must have realized, okay, the mistake which was done, okay, now we cannot do anything. We should have taken the precautionary measure. So that's why it's always advisable, especially for IP trademark, and then we should check all the documentation, ownership, anything. It should be checked before because you cannot do anything after that. So for this particular article which was there, it says the deal making is glamorous, due diligence is not. Okay, that simple statement goes a long way toward explaining why so many companies have made so many acquisitions that have produced so little value. You're acquiring a lot of companies, okay? A lot of merger and acquisitions are happening. But because we did not do a proper due diligence, we are not able to utilize it properly. Just one check before signing the document could have changed the complete agreement or complete deal. So in this, like if I just summarize, we covered the critical role of IP due diligence in business transaction, why is it required? We also covered the processes, considerations, which are there are pitfalls in everything which are being conducted through IP due diligence, and what should be the best practices to ensure effective IP due diligence. So this is from my side, and if someone is having any questions or anything, they can ask. I think I tried covering everything within time. I think I covered it like soon. So please let me know if you have any questions on this.
Yes, please go ahead. Any questions? I think the opening part of this session was very, very relevant, where we first of all understood the difference between IP audit and IP due diligence. That was the most important part, right? I mean, for our own selves, we conduct our IP audits. We keep a tab, we keep a check on, what are the intellectual properties that we have that are being licensed, that are almost obsolete today. So we will keep a tab of all of these through an IP audit. But due diligence is so very critical when it comes to, an M&A deal, or when it comes to licensing. That's when I think it's very, very critical. And Dr. Shivani, you brought in the most important points here. A lot of takeaway. And I think the highlight of this session was the checklist, which I'm sure a lot of practitioners here will benefit largely out of the checklist for due diligence. That was the most important part of this part of the presentation. Anyone else who would like to add or?
One question I have.
Yes, please.
This due diligence of IP is required only in the M&A transactions, or like what kind of transactions it is required?
It's not any kind of transaction. It's not mandatory that it should be M&A
Like the
transaction.
manufacturing agreement or joint venture also?
Yeah. Anything where IP transaction is where any money is involved, where IP would be considered, due diligence is required.
Ma'am, can you explain about cross licensing? Have you mentioned it in due diligence process?
So licensing, there are different parts of licensing, like sub licensing and cross licensing. Okay, so I'll just briefly explain this. So licensing could be exclusive or non-exclusive. Right? Exclusive means I'm giving the license to one person. Exclusive also can have two parts. Exclusive, I'm giving license to company X, means only company X can use it. The other kind of exclusive licenses, they can do it, I can also do it. That is also part of exclusive license. Non-exclusive license is I'm giving the license to maybe 5 companies at the same time. There could be a different terms and conditions, there could be a different uh, jurisdiction. And then sub-licensing and cross-licensing. So sub-licensing is I'm giving license to company X to manufacture my product. Company X, maybe they would be giving sub-licensing the same license to company Y to manufacture maybe one part of it. Okay, so that is sub-licensing. Cross-licensing, I'm signing a license, and then at the same time you are signing. So I'm giving you something, you are giving me something. The example I said that the process and product. So if there's a company who's selling a product in the market, that is more relevant for the chemicals or the pharmaceutical. I'm coming up with a different process which is very good in comparison to the existing process used for producing or manufacturing the product. So in that case, I can give license for my process to company X, and then they can. So there will be cross license. They will be giving license to me for the product. So they are using my process, and I'm using my process to manufacture their product.
Okay,
Is it clear?
thank you, ma'am. Yeah, ma'am.
Any other questions? Yeah, I think
The
that's pretty
question
much.
what I'm stating is out of the box. So when I open a YouTube channel, in the video they will mention a copyright act regarding the video. Okay, what does it mean, ma'am? Actually, is it they are taking the copyright or?
No. That's why I said it is not mandatory to have a separate copyright registration. Suppose I am uploading a video, maybe. So if I can give you example of these sessions. These sessions are being recorded by EBC, okay, and the recording will be available to the attendees. So EBC would be having a copyright on these recorded sessions. And if the recording is being shared with you, that means they are only allowing you to use these recorded sessions. Suppose you are sharing these recorded sessions with 10 of your friends for some money. Okay, that means you are getting some monetary benefits of something which is created or which is someone else's copyright. That is not allowed. Okay, so when you see YouTube videos, you cannot upload these recordings on YouTube, because the moment you upload, the YouTube will consider that this is your copyright. And later on, if EBC is sending a letter to YouTube saying this was our recorded videos and that particular person has uploaded without our information, there is a copyright infringement, YouTube will immediately take down that video. So when you see any video which is being uploaded on YouTube, it is being considered the person who has uploaded the video has a copyright on it. So you can see the video, you can download the video only for your personal use or for education and teaching. You cannot start circulating the video with others. So that is why most of the companies like YouTube or Amazon, Flipkart, they are very particular about IP. And the moment they get to know if there is IP infringement happening, they will immediately take an action. So that's why the warning will be there, or in the videos, maybe if there's something running, if there's on the bottom or top, it says that copyright belongs to a person or the company, that means it is a copyright protected thing. Even if it is not mentioned, any person who is watching the video cannot simply consider that this was not copyrighted. It is. Any person, it takes time. If you have a registration certificate, you can always show the certificate. I have a certificate from the government, and this is my copyright. But even if you don't have, you will have to prove by other means. But it can always be done. Ma'am, you are
And yeah, and I think Nagaraju also brought up a very relevant point about digital content, and that's precisely our next session also, which we are going to talk about. We have the next instructor coming up to discuss about digital rights management. So that's the next part of the session. And thank you, Dr. Shivani. It was a very, very informative, a very, engaging session. And I'm sure we've had a lot to, take away out of the session as law students, as practitioners, which they will take back for their learnings and for their as part of the session as well. Thank you so much. Thank you for your time on a Sunday morning and being with us through this session. Thank you so much.
Thank you so much. Thank you for having me.
Thank you, ma'am, for your valuable insights. Thank you.
And anyone else,
you.
if you have any questions, please do reach out to Dr. Shivani or reach out to us, and we will forward your questions to Dr. Shivani, and you can have your clarifications going further. Thank you.
Yeah.
Thank you all.
Thank you, everyone. Thanks.
And Dr. Shivani, you can just leave the session, not end the meeting.
I don't, I was just checking that. So I can see only end option. I'm not seeing leave option.
You're not, okay, that's fine. It's okay. So what we'll all do is Dr. Shivani will now end the meeting and we will all come back at 1:45. Is that okay? Because we are already at 12:50. 1:30 is the session, but we can just extend a little more. By 1:45, we can be here and we can get back to the third session for the day. Okay?
Yes,
Thank you. Dr. Shivani, you can end the session then.
Yeah. Thank you, ma'am.
Thank you.
Thank you, ma'am.
Thank you. Bye.